if there is a complaint against let's say a physician, the physician is the last to know. In other words, if they think that there's enough information that would warrant investigation, I call it the circle the wagon approach. So here's the target of the physician, and they talk to the complainant, then they talk to maybe office staff if that is pertinent, and they go to everybody else first. And then when they think they have the story, they then go to the physician. And then basically, based upon that information, a report is written, and it will go to, eventually it gets up to the disciplinary subcommittee of the respective board to determine whether or not there's enough information to warrant the issuing of administrative complaint. The investigator contacted the physician and said he would like to meet, and what I typically advise my clients is never meet with an investigator without an attorney, but my client contacted me. We, arranged for a mutually convenient time, and certainly we will come prepared and answer all the questions and provide probably additional information so that we're comfortable that the investigator has the full story. People don't also realize that even things like a reprimand or a probation can have devastating effects, because certain things like certain PPOs, okay, you might have a significant third-party payer that will say, well, I think a reprimand is a sanction, and you're going to be departicipated just on that alone. And so I take them very serious. And I also find that if you do your homework right from the beginning and you don't wait till till it's too late, and Virginia and I have had numerous conversations along those lines. If you do your homework from the beginning, dot your I's and cross your T's, a lot of times you can avoid the whole embarrassing, costly, emotionally draining process of a licensing action. You'll see another theme is that the interrelation, the kind of what I call the domino effect. It's very, very important that anytime matters such as staff privileging, criminal, licensing, they're all interrelated. And if one of these issues comes up, it's important that you consult with someone who can kind of look at it from the global perspective and advise you as to the various ramifications of these actions.
If there was a guilty plea to a felony, the Public Health Code provides that the license shall be suspended. Now, if you knew, for instance, there was a situation where a physician is going to plead guilty to a felony, I have had attorneys, Rob Iwrey, call me and say, I'm doing this in criminal court and I want to have the corollary, knowing there'd be a licensing action, I want to deal with this all at once. I want to have a global agreement. And my plea isn't going to happen until X date, and is going to be sentenced on Y date. And in the interim, let's get the licensing action going so that while that happens, we don't have to have, the summary suspension doesn't have to be such a gap in their practice that they're losing so much money.
I've had a case, this is years ago, where my doctor's license was summarily suspended. And so when it's a summary suspension, you just get a notice, and it's like, you got to stop practicing. I don't care if you got patients waiting in the hall, you got to stop practicing the moment you get that. Well, what happens is that you can have a special hearing to petition to dissolve that summary suspension before you get to the underlying case, okay? Just saying, hey, I can't, give me an opportunity to fight my underlying case, but I got to resolve this summary suspension. Well, if you want to convince the judge, the ALJ, that it's, worth dissolving the summary suspension, typically you got to take the stand, okay? Because the judge is going to want to hear. I mean, there's usually not a lot of witnesses at that point. Your license, every day that goes by, you want that license back. So you rush in, and then you realize, and in this particular case, I petition, I'm in there, and I've got my client, and my client's ready to testify, and I look out in the audience, and I recognize a couple people. He's from the OIG, he's from the FBI, and I'm thinking, wait a second. If I have him testify, he may say something that will incriminate him, and now I got law enforcement out there looking on a criminal case. So you got to weigh that and say, I'm not sure if I want to take the chance of just trying to go for the summary suspension lift if I'm potentially going to bind this individual in a criminal matter. And so that's really an important thing to take into consideration.
And let's talk first about the context of and the idea of conducting an internal investigation when you somehow suspect that there is a potential fraud that's being perpetrated in your office. And the question really often comes, who should be involved in investigating that particular activity? Is it you or someone in your office? Is it someone who is perhaps in a managerial position in your office? Is it someone that you employ on a regular basis as your outside counsel, as a lawyer? Or is it someone who perhaps specializes in healthcare fraud investigation, someone like Bob Iwrey? And if I were in that position, I would certainly look first to someone like Bob, or some of his partners like Jessica, who would have a better handle and a feel for the types of activities that might be problematic and might be violent of the criminal laws and statutes. Because you want somebody there who I think understands what the law is and can help you in terms of getting to the bottom of whether or not you have a serious situation or not.